Good morning, ladies and gentlemen. Thank you for coming today. I would like to recognize Representative Levesque for the Pledge of Allegiance, please. All rise. To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Again, good morning, ladies and gentlemen. I want to begin with opening the public hearing on House Bill 1036, which is relative to the maximum duration of term alimony. And I will call forward Representative Vose. Representative Vose, you've asked for and are given 3 minutes. Thank you.
Thank you, Madam Chair. Good morning, fellow members. And it's nice to be in front of Children and Family Law. I'm here this morning to introduce House Bill 1036. I'm introducing this bill on behalf of a constituent from whom you will hear later in this hearing. It's a relatively simple bill. We all know that New Hampshire is not a mandatory alimony state, but alimony is a tool that the state provides to families to deal with the dissolution of a marriage. And what this legislation does is it modifies the terms of those voluntary alimony agreements by putting a cap on the length of those agreements. That cap would be 8 years, or at least not to exceed 8 years, unless the parties agree mutually that it should continue for longer than that period of time. So it's a pretty simple idea. Why do we think it might be necessary? I introduced the bill because I thought it would be a good idea to have the debate and to have the discussion about why it might be necessary, and to also relate my own personal experience. I am a divorced man who later remarried. And when I decided to introduce this bill, I was having a discussion about it with my current wife. And she informed me that had I been stuck with alimony, as she called it, when we first got together, that we would probably not be married now. The question I think we have to resolve is alimony a mechanism to support someone during a difficult time, the dissolution of a marriage, or is alimony viewed by some as punishment, retribution? I would hope that it's the former and not the latter. But by putting a cap on it, we can ensure, hopefully, that it's not the latter. So that's my reason for introducing this bill. I'd be happy to take any questions.
Sorry, Representative Petrino.
Thank you, Madam Chairwoman, and thank you, Representative, for taking my question. I was just wondering if you had any concerns about long-term marriages where one of the spouses may be deferred education, wasn't employed, and came to rely on financial support from the other spouse. And now, being capped at 8 years, they go on into midlife and beyond without having any means of education or employment, and now no financial support. Just some of your thoughts on that scenario.
Thank you for the question. That's a good point, and one I have thought about. And it seems to me that 8 years is a fairly lengthy period of time. And if we all believe that each of us is responsible for our own life, then I would think that an 8 year period of time would be enough time for someone to recover and chart a new path in their own life, rather than depending upon someone else. In fact, I know in the dissolution of my own first marriage, I was actually anxious to chart a new path forward in my life because the way our life was going prior to that was not particularly good. And I know my ex-wife felt the same way. So to me, an 8 year period would be adequate to allow someone to recover from the actual separation itself, but not so long as to burden either party long term.
Thank you. Representative Gregg.
Thank you. I actually want to see if I could do a follow-up to his question, and then I have my own follow-up question. So if a couple, thank you, by the way, for letting me have a question, and thank you for taking my question and for being here. So for a couple that's married 25 to 30 years, where one spouse was out of the workforce, maybe didn't go to school, whatever else, but now they're in their 50s and 60s, how does 8 years make up for that? I mean, it's harder to get a job at that point. So why 8 years when they've spent 30 years, thinking this was an agreement? Normally there's an agreement. If one spouse is working, the other one is not. They've raised the kids, they're taking care of grandkids, whatever. So now they're 50s and 60s. How do you expect them to make up that difference in only 8 years?
Well, I'll return to the answer that I gave to the previous question. 8 years is quite a long time, and someone that late in life probably has a future plan for the end of life and the retirement section of life. One would hope that that included provisions for both parties. In addition to that, this cap is negotiable. If both parties want to continue it, it's not an automatic cessation of the alimony. You can continue the term if you like.
Representative Gregg, follow-up.
Oh, yes. Thank you. Thank you for allowing me a follow-up. So other states that have hard caps, so like Texas, scale the maximum duration based on how long the marriage lasted. Why have you decided on this hard cap at 8 years?
I personally didn't decide on 8 years, and there will be someone testifying after me who might have a better answer to that question. That person suggested 8 years, actually.
Representative Georges.
Thank you, Madam Chair. Thank you to take my question. I just want to ask, because you say if it's a punishment, what do you mean about punishment?
So I have experienced in my lifetime people who have dissolved a marriage in a situation where alimony was mandatory, and one party expressed during the divorce proceeding that they thought they were entitled to alimony as retribution for the dissolution of the marriage. That's not an uncommon feeling, particularly when there is real animosity in the dissolution of a marriage. In my own marriage, our parting was mutually agreeable, and both parties wanted it, so there was no rancor or ill feeling about it. But I've known many other couples who broke up, and there was a lot of bad feelings, and alimony was often considered as punishment for one party or the other.
Follow up,
Follow-up.
please. Thank you, Madam Chair. Because it's a punishment, because sometimes when we marry, the man is going to tell the wife, you stay home, take care of the children, start to have the children, start take care of the children. After the children are grown up, you divorce. Now, that woman didn't even work. She didn't even do anything because she was just maybe she was even work when before marriage, but because start to have the children, some men say you stay home, you need to take care of the children, not working because she's working, and after that is a divorce. What that woman gonna do if it's a punishment?
Well, in my case, I know that the dissolution of my marriage happened in the presence of a mediator. My ex-wife and I hired a mediator to mediate how we would split up our community property and how we would take care of ourselves going forward. And we reached a mutual agreement about how to do that. I'm not going to give you all the details, but it was mutually beneficial to us. And we were able to move on with our lives afterwards. I've heard many instances of couples where breaking up, where that mutual agreeability was not part of the divorce, and there was lots of rancor and a desire on the part of one or sometimes both parties to punish the other party for the dissolution. And I would certainly hope that alimony wouldn't be used in that sense, and this would be a way to make sure that it didn't get used that way.
Thank you, Representative Scher.
Thank you, Madam Chair. So it's not up to the parties, unless they agree, it's not up to the parties to determine alimony. So even if one party is rancorous, the judge gets to decide, isn't that right?
Yes.
So the follow-up. So the presence
Follow-up.
of rancor on their desire for retribution on the part of one party doesn't mean that that's going to be reflected in alimony, does it?
Not necessarily, no.
Follow-up.
Final follow-up.
And the current bill doesn't say that the person who is receiving alimony gets it for the rest of their life. Instead, it says they get it for 50% of the length of the marriage. So in the 30-year circumstance, the individual receiving alimony would only get it for 15 years. So it's not 8 years or to the end of their life, is it?
No.
Thank you.
Representative Rice.
Thank you, Madam Chair. Thank you, Representative, for taking my question. So I have concerns about the spouse that will work to put another spouse through school, and then that spouse will end up staying home with the children at the lack of their own education to be able to, find a good job. As in the case would be, what if they divorce in their 50s and this person has, over 25 years of no work experience? It's just not that easy to get back out there. And so I have some concerns about this.
Okay. That was not a question,
Oh,
but
sorry. Would you believe? Sorry.
Good girl. Representative Pearson.
Thank you, Madam Chair, and thank you, Representative. But in any of these worst case scenarios, does it not seem that the court can change this, because the bill says so, that the worst case scenarios are not mandated by this bill, the judge may overrule?
I believe that is true, yes.
Thank you.
Representative Gregg.
So on that note, with it saying that it actually says that the court to exceed 8 years only if justice requires, but the existing modification standard under RSA 458.19 AA requires clear and convincing evidence of substantial and foreseeable changes in circumstances. That's a really high bar. Do you think that's appropriate since you're lowering this so much?
So I'm not going to comment on the value of the existing legislation. I'm here to comment on the change to the legislation that this bill provides. I'm not going to make a value judgment about the correctness or the value of existing state statute.
Seeing no other questions. Oops, I'm sorry, Representative Markel.
Thank you, Madam Chair. And thank you for taking my question, sir. Okay, so if I understand this proposal correctly, you're interested in changing the social policy behind alimony. Would that be fair to say?
Actually, I think I'm more interested in changing the legal policy behind alimony. If it has the side effect of changing social policy, maybe that could be true, but that's not the purpose of the bill.
Okay. Follow up?
Follow up?
Thank you. Okay, so before the change of the present alimony statute back around 2018 or so, the stated policy of alimony was to provide rehabilitation. Basically, the main function of alimony was rehabilitative in nature. From your prior testimony, sir, that's what I'm sensing it is. And would this be a change in policy where under RSA 458-19A, the purpose, for example, when we're talking about term alimony, is to allow both parties to maintain a reasonable standard of living? So would that constitute a change in your opinion, sir?
No, I
Okay,
don't think so.
thank you. No further questions.
Representative Gray?
Thank you for indulging me. One last question, because this is like a rabbit hole here. But if a long-term alimony, let's say 15 years, if they've been married 30 years, and that it could be even more, they've been married 50 years. I one time worked in their quarters office, had a 95-year-old that came in and wanted to divorce his wife. But if we're looking at that as a possible punishment for one spouse, which statistically speaking would be the husband. Statistically, the male usually makes much more than the female. So would it not also be seen by lowering this alimony to 8 years, which is in a lot of cases, a very, very low number, as punishment for not staying married?
I view the 8-year time period as a freeing of the parties to pursue the rest of their life without continuing to be connected together by their previous arrangement.
One final question.
Thank you, Madam Chair. Fair to say the underlying statute here also says that, with some conditions, alimony ceases upon retirement of the one paying the alimony. Is that correct?
I believe so, yes.
Thank you.
Thank you, Representative. Seeing no more questions, next I'll call Gary Carlson. If you can give it to Representative Scher, that would be perfect, sir. Thank you. And Mr. Carlson, you've requested 5 minutes. It is the rule of the chair that everybody gets 3 minutes. And then you can answer questions if you so choose after your 3 minutes is up.
Okay, I'm
Okay,
usually, thank you.
thank you.
Thank you, Representative Bose. And thank you for all the questions prior to me sitting in the chair. I am a long-term marriage divorcee. I had 32 years of marriage, so 16 years is my term based on the 2019 change in the law. Representative Markel, I believe, referred to what was previously known as rehabilitative alimony. And for several attorneys in family law that I've discussed, the average, from what I'm understanding historically, was 5 to 8 years for rehabilitative alimony. So my understanding also of the alimony change in 2019 was to expedite things in court because it was really sluggish. So a formula was created to determine the amount of alimony based on the delta between the gross wages of the person paying alimony and the person receiving alimony times 23%. And then the term was half the length of your marriage. So relatively simple formula on paper, really, again, designed to, my understanding was expedite divorce cases. But really, the bottom line, in my opinion, was that expediting a formula kind of took out the practicality and fairness, in my opinion, for divorces. If we look at the alimony law, the purpose of term alimony is to allow both parties to maintain a reasonable standard of living. The party in need of alimony generally lacks sufficient income, property, or both. For me specifically, we did want a traditional stay-at-home mom. We both agreed on that. There's no one that can raise your children better than their own mother, even better than her father. That's just natural. We totally agreed on that. We had a pretty good run at 32 years. We raised our 3 boys. I was the full-time, financial support for the family, but I also was very involved with the family. I did just as many chores. I cooked just as many meals. I washed just as much clothes. And my ex-wife, she eventually got back to work part-time with the full intention of her last full-time job was a bank teller. The full intention was for her to go back to work once our youngest got into about 9th grade, so that we could retire earlier. She never went back to work. So as it turned out, that gross delta was her part-time work, my full-time work plus bonuses. So she gets an alimony about $38,000 a year, which is close to what the average full-time income is for a female in New Hampshire.
30 seconds.
So the 8 years is just a cap. Again, it mirrors what used to be considered rehabilitative alimony of 5 to 8 years. So it's on the higher end of that. It doesn't mean that the court can't move that further up. If my ex-wife has a lot of assets, she sold a marital home for a large profit and has no mortgage on her current house. I took a loan from my 401k to get 5% for the house I live in.
Sorry, sir. Can you wrap it up? Your time is up.
So I'm just asking for support for the 8 years. It doesn't set it in concrete. The parties can agree on more. If there's a person in need of alimony that has no assets from the divorce, they'll likely get more a longer term.
Thank you, sir. Any questions? Representative Gregg?
Thank you, Madam Chair, and thank you for taking my questions and for your testimony. Are you aware that the 2018 reform, SB 71, that deliberately chose 50% marriage as that length, are you aware that the judge is able to adjust that as he or she sees fit right now?
Mm-hmm.
Thank you.
Representative Rice?
Thank you for taking my question. So I would like to hear your aspect on the position that you had stated your wife did work, and then eventually decided to get back into the workforce part-time. But I have to think during that time frame, had she been working, that any promotions, any advancement in companies have been bypassed during that time, and they would basically be starting over. So I have to, and in the meantime, the other spouse is able to, I'm getting to it. I just lost my track of thought, but can I get your take on that and how you feel that that should be handled then?
It's a good question. I would say that when my wife stopped working full-time, she was a full-time bank teller. She had been doing that for about 4 years. When she went back to work part-time after our 3 children were born, I worked part-time before the 3rd child was born to help support. So I worked full-time and part-time while she was a stay-at-home mom. And she went to work for veterinarian. Just she had horses and dogs, so she just went there to also get a discount on animal care. So that's what she did, and that's what she did for a long time. But her plan, the goal of ours was for her to go back to work full time, so that again we could retire earlier together. And she chose not to go back to work full time.
Thank you.
Representative Raymond.
Thank you, Madam Chairman, and thank you for taking my question. Sorry, I have just dropped something. And this is a technical question about the bill, and if it takes effect January of next year, does that mean that current orders are subject to go back and be changed? Like, does that authorize people who have a current decree to go to court and ask for it to be changed? Or does that just mean that new cases as of January 1st next year? I guess it's kind of that anyone can answer.
That is a technical question that we can find out later on. I believe that typically the legislature does not legislate for anything that has happened. It only legislates for things that do in the future happen. So, but you can check with legal to be sure on that. Thank you. Representative Scher.
I can present a little more insight. Generally speaking, because it doesn't say this is retroactive, it's not retroactive. But what will
Correct.
happen is a judge, if somebody goes back to change the length of the payment of alimony, a judge will look at what the new law says and may be more amenable to changing.
Thank you, Ms.
Practically.
Thank you, Representative. Thank you. Seeing no further questions, thank you for your time.
Thank you, everyone.
I'll next call Mary Kruger. She has asked for the regular 3 minutes.
Madam Chair, was there handouts coming around?
There weren't enough.
Okay.
There were not enough to go around. So maybe you can ask another representative to share with you. Thank you. Yes, Representative.
Thank you, Madam Chair. Since he already had this in type font, maybe the last witness could email the committee
Can you do that, sir?
because we didn't have enough. Thank you.
Thank you, madam, for
Okay.
waiting.
Thank
Welcome.
you. Thank you, Madam Chair and members of the committee. Good morning. My name is Mary Kruger. I'm an attorney at New Hampshire Legal Assistance, a statewide nonprofit providing civil legal services to low-income people and older adults in New Hampshire, helping them to meet their basic needs and safety. I supervise the Domestic Violence Advocacy Project there. We also have a Justice in Aging project. We opposed HB 1036. Many of the reasons around here with the questions, a main concern is what this will do to women in particular later in life. We did spend a lot of time in 2018 working on making a change to the alimony law that really tried to have more predictability in that law and to ensure that there's fairness for the parties. The court still needs to look at the need of the person requesting alimony and the ability to pay for the person who is being asked to pay for the alimony. If those two hurdles are overcome and are met, then the court turns to the formula. What this does is adding that 8-year cap is it sort of flips what the current law allows for. the current law will allow for the court to have the maximum duration of 50% of the length of the marriage, unless there's special circumstances. And if you look at the special circumstances, it's not actually clear and convincing evidence for the special circumstances. It would be a preponderance of the evidence to demonstrate whether or not that should be adjusted upward or downward. And so the court does have the discretion to do that by creating this 8-year cap. That person who needs more than 8 years, that long-term marriage where it would otherwise under current law be like 15 or even 20 years, would now have to demonstrate a special circumstance exists to have a longer term. So we believe that this will put more, in particular, women in poverty later in life when it's harder to get back to work and to rehabilitate their earnings. Thank you.
Thank you. Any questions? Representative Nelson.
Thank you, Madam Chair, and thank you for taking my question. I know that we currently have in law sorry, I can't think of the word at the moment. But when a spouse receives a certain part of somebody's pension, so that would be ongoing for many years after 8 years potentially. So if this were to go into effect, would that interfere with those orders?
No, so the way that the alimony law works, where Representative Scher had said typically it will terminate at the time of the age of the retirement of the person who's paying, that is meant to sync up with that the spouse of that person who's retiring is also entitled to a portion of whether there's a pension or a retirement account of some, that they would then be able to access those funds at that time. So it's sort of like alimony should take you to that point, especially for a long-term marriage where it's later in life, so that at the spouse's, the payor's retirement age, that other spouse would be able to access that income.
Thank you. Any further questions? Thank you very much for your testimony.
Thank you.
At this time, I'm going to recess 10:36 for a few seconds. I'm going to open House Bill 1210, which was scheduled for 10:30, and I'm going to immediately go into recess on House Bill 1210, and I'm going to reopen the hearing on House Bill 1036, and I'm going to call on Jan Gonsalves. Come on forward, sir. You've asked for 5 minutes. The committee is for 3. Thank you.
Thank you very much for giving me this opportunity to speak. I think my experience has been a little bit different than everybody else's. During my 21-year marriage, my wife was a full-time employee the entire time. She at COVID, she worked as an MRI tech. COVID basically shut all of that down. So she stopped working at that point, and then decided she only wanted to work part-time from that point forward. We went through divorce proceedings starting in 2023, still going on. But the judge did not use her ability to earn. Again, she's fully capable of working full-time. She chooses not to. He did ask her to start working more at the temporary hearing. She chose not to. She basically, she told me that I was going to be paying for her not to work, and she has followed through on that. And so she makes $47.50 an hour. Her need was calculated to be $90,000 a year. She can make that if she just worked full time. She chooses not to. The judge imputed a salary to her of $80,000 because that was her previous high prior to COVID 5 years ago, and then calculated a need of $10,000. Actually, it was $12,000 because it's $1,000 a month. But again, she could work full time. She just chooses not to, and that now has become my responsibility to subsidize her need. It's not a child care issue. My youngest child is 16 years old and lives full-time with me. This is punitive, is what it is. And again, so we were married for 21 years. The judge gave her the full half allotment of time for alimony. Again, this is someone who is working and can work full-time, just chooses not to. Her skills are fully there. So my experience, I think, is a little bit different than what everybody else is talking about. And even though the court could change the number, it's a formula. They're just saying, yep, this is the formula, we're applying it. So I know you're about to hit me, so I'll stop.
Thank you. Any questions? Do you have written testimony, sir?
I not written. I had a statement that I wrote, and then I had a handout
Okay.
for some things that I would suggest.
If you could hand it to Representative Scher, and then are you willing to take a question?
Absolutely.
Representative Gregg.
Thank you, Madam Chair. Sorry, I was like sitting here thinking about it and going through your testimony. So in looking back, did you say that your divorce is still ongoing?
It is a final hearing was had, verdict, and it is under appeal because of various technical problems with the ruling.
Okay, just making sure. Thank you.
Thank you. Final pink card, I will call Joseph Barton. You asked for 1 minute.
1 minute only. Thank you, Madam Chair.
You're very welcome, sir.
Representative Joseph Barton, Grafton District 1. I support this bill. The one thing that you may not have heard is an abusive process in the family courts whereby one party who would benefit from alimony will push the proceedings out and delay proceedings to 4 or 5 years. And they recoup half of that in alimony. So to have an 8-year cap makes sense to me because, well, what is alimony? It's a support order. After you have your contractual agreement with your former spouse, one party still has to, I guess, provide to the other one, even though they're not married anymore, which I don't fully understand. But to the extent that support is necessary, they should be able to find another spouse within 8 years if they want spousal support. So I think that a cap makes perfect sense, and it prevents the abuse of process in marriages of 20 years or so. And it further prevents, because when you file for divorce, it's not from the date of filing, it's from when you get the final decree, which could be 4 or 5 years later. So it makes sense to have a cap at least. And that's all I have to say. I will not take any questions. Thank you.
Thank you. And with that, I will close the hearing on House Bill 1036, and I will reopen the hearing as soon as the clerk has her work caught up. Are you sure? The clerk is all set and ready to go. I'll open House Bill 1210. And the only card I have is from a Chris Andrews. Is Chris Andrews here? You've asked for 5 minutes. You can have 3. Representative Barton, are you going to introduce your bill?
I can.
Okay. I need a pink card from you. Yeah. Okay. I did not have it, so that's why I didn't call you first. Representative Barton, please.
Thank you, Madam Chair. Sometimes I don't always think it's an advantage to go first, but in this case, I do have some written testimony that I'm going to pass around. I'll give you the basic background on this proposed legislation. Basically, child support, even alimony, which this doesn't address, but child support used to be able to get a tax exemption for it when you filed your federal income taxes. We don't have taxes in the state of New Hampshire, so we don't have to worry about it as a state. And the courts kind of set up, whoever gets the child tax credit, but whoever was paying still has to pay tax on child support on top of what's ordered. So where they used to get a benefit from filing their taxes, they no longer get that, and that's effective, I think, in 2018. Why? Why did the feds decide to get rid of that? Because there was no clear clarity as to whether they were actually paying the support. Some people were paying or were not paying their support, but still claiming the tax exemption because of the order. This legislation does away with all of that. It still allows for provisions. If you don't pay child support, you don't get to claim the tax credit. You have to claim the support. It also sets up a system where you're not going to get the tax credit unless you actually pay a significant portion of child support where it would make it meaningful. Judges would still have discretion in that case. So what it really does is it brings back that kind of fairness that we had pre-2018. It aligns child support orders by reflecting how federal tax law actually works today. It encourages compliance with child support orders, and it treats parents fairly while prioritizing the child's financial well-being, and that's the purpose of child support. That's all I have on this. I'm happy to take questions.
Thank you. Representative Rice.
Thank you, Madam Chair. Would you believe that both parents support the child, not just one parent sending in child support, that other parent supports that child also? And the reason for child support is to have that equality in the raising of the child. So therefore, both parents are supporting the child. So why would just one get to file?
So this is about child support and finances. Any other type of support is completely different. And especially in cases where I assume, or we're kind of a 50-50 state, that both parents support equally. But with financial support, it's always one party. It's never two parties. One party's, I'm not finished answering, but one party will always pay more than the other unless there's no support ordered. So yeah, the tax portion isn't what's adjudicated by the judge. They only adjudicate what the child support is. A judge can't say, oh, well, you get the benefit from the tax credit, or you get the benefit from the tax credit. Because the 2018 did away with the exemption. And so if you had the exemption, believe me, you would probably make more in claiming the exemption if the Fed went back to that. And I wish we would. But would I believe that it's equal? It's absolutely not equal, because it's always one party over the other. It's never financially the same, ever.
Do you have a follow-up, Representative Rice?
Oh, yes, I do, Madam Chair. Thank you. So then my question is, so what is the parent that's not the parent that's receiving child support? Are you saying that the parent paying child support is covering all costs for the children? All costs, that the other parent is not providing any support, especially if the children lives with them?
Well, what I'm saying is the parent that's receiving child support does not have to pay taxes on that money. That money is given to them tax-free. It doesn't even count as income for them. That's what I'm saying. That's why that parent shouldn't be entitled to it, because the other parent has to pay taxes on it before they even give it.
Representative
fact.
Gregg.
Thank you, Madam Chair, and thank you for taking my question. So we had almost an identical bill to this that you brought in, was it 2 years ago or
Yep.
last year?
Yeah. Yeah. I
So-
changed a few things.
This, you qualify a significant amount. What does that look like? Like if a person is paying a significant amount, what is the denomination for that?
That is so if you make if you're paying if the tax exemption, if the disparity in child support, let's say that one party's paying the other party $10 a month, and that's what the court order is, and the other party receives $120 at the end of the year. Well, a tax exemption for the child wouldn't make sense because what you're paying the other party is well under what the $2,000 exemption would be.
Have a follow-up?
Do you have a follow-up, Representative?
I do.
Okay.
Thank you. So let's say that we have a parent paying $100 a month. Would you agree that that's significant?
Probably not in today's
Okay, but
standards.
for that one parent, it could
Yeah.
be a significant amount of money. However, if you get to the end of the year, it's $1,200. Let's up it, let's say 200 or whatever, so it gets past your exemption threshold of 2,400. So you have 2,400 at the end of the year. Do you think that the person receiving that 2,400, that's all they spent on the child during the year?
I think that the person receiving it's not up to the judge to decide that they received an extra $2,000. If the judge felt that they needed more money in child support, they would order it. But because they didn't, they have absolutely no purview over money that the Fed gives out.
Clarify.
Clarify.
So I wasn't saying that what the judge ordered. So maybe that's all the one parent that's paying child support can afford, because they do base it on that too. It costs a lot to raise children, but the judge is responsible for looking at a parent and saying, we can't put a parent underwater. If they can
They
afford
do that. The
afford
family courts do that.
$100. So in this case that the judge said this is all that they can afford, why would the person that's not paying for the majority of the child's expenses during the year, why would they get that tax exemption?
I'm not sure that they're paying for how are they paying for the child? Are they paying using the child support that they receive?
Well, the $100, the person paying the $100, or $200, so it's like $2,400. Why would they get to, under this, that's a significant amount of money, so why would they get to claim the child? I guess I'm wanting you to explain this in a real world kind of example.
That's not a significant amount of money because the benefit would be less than $2,000, the $2,000 child tax credit. So it wouldn't be significant.
Thank you. Representative Pearson.
Thank you, Madam Chairwoman, and thank you, Representative, for taking my question. I may be missing something here, but is this not an attempt to pass a law in New Hampshire that speaks to federal issues? Because we do not have an income tax here. The only income tax credit out there now for us would be federal, and we do not have standing to do this. Is that not correct?
I would say it's not correct because judges in their decrees issue who gets to claim the child. So to that extent, then I guess they do have purview over that aspect of federal law. Otherwise, would both parties claim the child? Would they claim half the child? How does that work? It's always in the decree. So I think you're incorrect there.
Follow up?
Follow-up.
Even though you led off by speaking about the federal tax exemption thing went away in 2018, we're still talking federal here, are we not?
Yeah, I'm not talking about federal tax exemptions or calling for the Fed to reinstate those exemptions. Because this is not about tax exemptions, it's about the child tax credit, who claims the child. And as I testified earlier, if one party was to claim the maybe $20,000 or $30,000 that they spend in child support a year and reduce that, claim it as an exemption, they probably get more than $2,000 in a reduction from that, even if they don't claim the child and the other party claims the child.
Thank you. Representative Raymond, do you still have a question?
No, it was the same as Representative Pearson's question.
Thank you. Representative Scher.
Thank you, Madam Chair. Are you aware that federal tax law allocates the child tax credit to the custodial parent unless there is a waiver signed by the custodial parent?
That is factually incorrect, and I looked at that this morning. There's no such law.
No further question.
Thank you. Seeing no more questions, the next person I'll call is Chris Andrews.
Thank you, Madam Chair and members of the committee. Let me start by thanking all of you for your service to New Hampshire. I served in the New Hampshire House of Representatives back in 2012, and I thoroughly enjoyed my time in this group. I'm here to oppose HB 1210. I want to share the story of two people that are very close to me. The child in this case is 7 years old, and she is raised by her mother alone. As a single parent, she alone raises her daughter, feeds her, houses her, provides for her health and safety, cares for her when she is sick, and makes sure she's at school on time. And as a single parent, this all comes at a great financial cost. Dad, in this instance, is a term used to describe him scientifically. He left in April of 2020 and hasn't been seen nor heard from since. His only interaction with his child is the court-mandated child support he's forced to pay by garnishing his wages. He chose to have no part in raising this child. He doesn't call, doesn't send birthday or Christmas cards, doesn't care enough to want to know anything about her. Due to the general lack of available childcare, primarily before school, Mom has only been able to work part-time service-related jobs in the last 5 years. As a result, there is no paid time off to care for a sick child. To add to this financial burden of raising her child, Mom has been terminated 3 times because she's raising this child alone. She's been asked to work nights and weekends and has endured several instances of work absence to stay home with her child due to illness, and the results, termination because she cannot meet her work obligations. The child tax credit in this case is utilized to assist with the day-to-day expenses of raising a child, be it clothing, housing, or perhaps a dance class. It wasn't intended to benefit non-custodial parents who skipped out on his family, whose only relationships to him amounts to a financial obligation dictated by a judge. Raising a child as a single parent is a huge financial obligation, which is lessened by receiving the child tax credit. Allowing the non-custodial parent who chose to walk away to benefit from the child tax credit would be financially cruel and an insult to the single parent raising their child alone 24/7, 365 days a year. I want to make one comment on the previous speaker, the sponsor, when he talked about the child support not being counted as income. In relationship to the state welfare rules, it is. I take care of this mother's welfare benefits. She's been on public assistance since 2020, and it is very clearly stated that the child support is counted against her when calculating SNAP and TANF. So he is correct in saying that it's not counted on the federal income taxes, but where the rubber meets the road in providing food and cash assistance and medical care, it absolutely is. Thank you, Madam Chairman. Everyone.
Thank you. Will you take questions?
Absolutely. I'll try.
Questions? Representative Gray.
Thank you, Madam Chair. And I just, would you believe that we're very, very grateful for your service and your testimony
I would
today?
believe that. Thank you.
Thank you again.
Thank you all.
I have One final card, Mary Krieger.
Thank you, Madam Chair, members of the committee. My name is Mary Kruger. I'm with New Hampshire Legal Assistance. We're a statewide nonprofit law firm providing civil legal services to low-income clients and older adults in cases involving their basic needs and safety. We're here to oppose HB 1210. This would actually create, I think, a lot of confusion in our courts. So I'll talk about some things that haven't been addressed. There are actually 3 different tax credits for children, and they all have different requirements and different income levels to be able to get one of these credits. They're credits, not deductions on the tax forms. The earned income tax credit is one that is for people who are at 61,000, less than $61,000 annually, and the maximum amount of that credit would be $8,046. So this is significant credits that are, the policy behind these are to help low-income families, and allotting that kind of money to one parent over the other in a court order and making it mandatory in certain instances really could disadvantage low-income parents who are dependent on that money in order to afford their basic needs, and that could actually increase people accessing public benefits. So for that reason, we really do oppose this change, and I do think it would actually be very difficult to implement for the court, where the court currently has the ability to factor in which parents and how to allow for children to be claimed as tax dependents. And there are IRS rules about this, and if the court does order that a sort of, quote, non-custodial, that's the language under the IRS rules, parent is entitled to claim a child as a tax dependent, the other parent does need to fill out a form 8332. Thank you.
Thank you. Any questions? Representative Rice.
Thank you, Madam Chair. Thank you for your testimony and taking my question. So, is it practice now that, especially where we just went with the shared parenting, that if both parents have shared parenting, perhaps they alternate the years for the child tax credit? It isn't always delegated to just one parent?
That's correct. And in my experience in doing this for close to 20 years, oftentimes they'll sort of, if there's multiple children, they'll split them up so that everybody can sort of have an equal number over the years, or if there's just one child, they switch every other year. So that's often how the court will handle those things.
Thank you very much.
Mm-hmm.
Thank you. Any further questions? With that, seeing no further questions, I'm going to close the hearing on House Bill 1210. And I'm going to open an executive session on House Bill 1210. And do I hear a motion, Representative Rice?
Thank you, Madam Chair. I move ITL on House Bill 1210.
Second.
Moved by Representative Rice, seconded by Representative Gregg. Any further discussion? Madam Clerk, will you please call the roll?
Representative Rice.
Yes.
Representative Pearson.
Yes.
Representative McMahon.
Yes.
Representative Nelson.
Yes.
Representative Love.
Yes.
Representative Corzine, yes. Representative Markell.
Yes.
Representative Petrino.
Yes.
Representative Scher.
Yes.
Representative Levesque. Yes. Representative Gregg.
Yes.
Representative Raymond.
Yes.
Representative Georges.
Yes.
And Representative Malone. Oh, sorry. And Chairman DeSimone.
Yes. Seeing that it's unanimous, do I hear a motion, Representative Scher, for consent? Any objection to consent? Seeing none, thank you very much.
If needed.
Yeah.
If we need it.
And when the clerk is ready, we'll open the next hearing. For full disclosure, we opened the exec session per the announcement in the calendar stating executive session on pending legislation may be held throughout the day, time permitting from time to time. The committee is initially convened. So I just wanted to make that full disclosure, and now we will open House Bill 1225. I believe Representative Markell is going to grab a pink card for the record, but we will indulge him and let him give his introduction to the bill. You're very welcome, Representative.
Okay, I have some handouts.
Representative Scher, I must say you're doing a phenomenal job. It is on the record, sir.
Thank you for your service.
Oh. Sometimes grown men need a mom. Representative Markell has handed some handouts. Hopefully there'll be enough and we will get them to you ASAP. As Representative Markell relaxes, has a seat, and gives his opening statement.
Okay, thank you. And thank you for allowing me to present this bill. In essence, what it does is that it adds a couple of new items to the calculation of the child support calculator. What I've handed out here is two versions of a child support worksheet. The first one has a little ink notation on the left side of the child support worksheet, and the second doesn't have it at all. And I'll explain, first of all, what this bill is about. right now, when you look at RSA 458C, we have certain deductions that are factored into a child support order. What are missing, in my opinion, is two that I think make some sense. First, when you look at the child support worksheet, you'll see, if you look at the top, you'll see the payment calculations, and then you'll look at monthly gross incomes, and then you look at the adjustments that are made. They are court-admitted ordered support for others, 50% of actual employment, self-employed income taxes, mandatory retirement, actual state income taxes paid, and then it goes down to allowable child care and medical care paid for the children. What I'm proposing is to make child support payments slightly more equitable, is adding the deduction, basically the 1/2 deduction for an employee to be able to claim Social Security. And I'm also adding the Medicare portion of the deduction that most people get in their pay stubs. Both employees and employers have to pay that. In terms of the scope of the problem, well, let's see. The latest statistics I have from the New Hampshire Judicial Branch indicated that out of a total of 14,448 cases that were heard in 2024. I wished I'd had the 2025 available. It would be good. There were domestic relations matters were 6,604. So I'm not sure how many of those are child support cases. Guardianship of minors, which might involve some support, 911 cases. Total would be 7,515 out of a total of 14,448 cases. Those were new filings in 2024, not existing filings. I also am aware that the Bureau of Child Support Services also manages a substantial number of child support cases. The last number that I had seen, and I don't know if it's accurate or not, was in excess of 35,000 cases of child support. So the situation is substantial. Those numbers could be subject to change. The major points here is that when you look at the calculations, it does make a small alteration in the child support calculation. Looking at the first child support guidelines worksheet, we would see that an obligor who has, and by the way, these incomes are based on real numbers from a case. I didn't make these up. So if we look at one obligor who makes $6,684 a month, and to simplify this, I didn't add any of the additional factors, but just to show the difference of what happens if you use a Social Security and Medicare deduction for the obligor. So on that particular case, if you look at page 2, the net child support payment, if nothing else applied, would be $1,016. Looking at the second sheet, if this were not factored in, the child support payment would be $1,055. So that's a difference of approximately 3.8 to 4%. Now, at first glance, it doesn't sound like much. And the whole point of it is that it is to be used in conjunction with the other calculations that go into the adjustment on the income. And let me give you a little bit of background on why I think it's relevant. Okay, first, as I think most people know, neither child support nor alimony in federally is considered taxable income. It's not deductible to a payer as a deduction on your income taxes. It's not reportable as earnings to the IRS. It's also my understanding that the obligee who receives the child support payment doesn't have to, also, it's not subject to Medicare tax and it's not subject to Social Security tax. However, the obligor does make that payment, and that payment comes off the top for the obligor. And that payment comes off, and remember that that's net right now as the law stands. Okay, that doesn't include the Social Security income tax, the Social Security tax that the obligor pays, and it doesn't include the Medicare tax that is also deducted from the pay stub. Now, in terms of where this goes, according to Social Security, the tax rate for 2026 is 6.2%, and that would be up to about $184,500 worth of income for employees or employers. The Medicare tax rate is present for 2026.
30 seconds.
Okay, I'm sorry, I'll run it fast. Okay, is approximately 1.45%. Maximum Social Security income tax, $11,459 for 2026. If you make more than that, the additional Medicare tax is 0.9%. That comes from the IRS publications. So since these are not reportable as income, and since RSA 458-19A term alimony adds it as income to the obligee, clearly the obligee does obtain some benefit from it. So what I'm asking that we do is that we consider this in making these adjustments to income to make it fairer for the obligee, make it fairer for the obligor, okay, who may feel a little better about paying their child support and the perception that it will be fair. Like I said, it's 3.8 to 4%. It's not a huge adjustment. I'm happy to take any questions, and thank you.
Representative Petrino.
Thank you, Madam Chairwoman, and thank you, Representative, for taking my question.
Sure.
The little bit of research that I've done, and please correct me if I'm incorrect,
Okay.
is that self-employed individuals can now deduct the employer equivalent portion of their self-employment tax to lower their AGI. In other words, currently, the federal law does permit Social Security and Medicare to be factored into that adjusted gross income. Correct me if I'm wrong, that's a little bit of the research that I've done, and if that's the case, would this legislation be necessary?
Yes, it would, because that's self-employed. We're talking about employees who don't get the same option.
Representative Love.
Now I'm more confused than ever. Thanks for taking my
Sure.
question. Okay, adjusted gross income means gross income less, okay? If self-employed, 50% of actual self-employment tax, which is your Social Security tax.
Right.
Okay, and Medicare taxes. Yet if you're an employee, okay, you get to deduct it all.
You don't get that.
You don't, okay, I'm reading this backwards then. Okay, question answered.
Okay.
Thanks.
Sure.
Representative Gregg.
Thank you, Madam Chair, and thank you, Representative, for taking my question. So this bill will reduce adjusted gross income across the board for obligors, meaning that custodial parents will receive less child support. Have you coordinated with the state's child support division to model that fiscal impact, particularly on low income households?
No, I have not. But typically, if you look at it, I gave you one example to show. Okay, so that in and of itself results in a 4% difference. And what I'm trying to do is make this more equitable for both parties. Consider the benefit to an obligee of receiving what amounts to completely tax-free income, and consider the cost to the obligor who gets no such deduction. So once again, the obligor has the money taken out of his or her check, okay, and still has to pay the tax on the money that the obligor never gets to keep. So that Social Security and the Medicare tax still comes out of it.
Follow up, please.
Follow up.
And just to clarify one more time, so this is an actual child support case that you had? Like this is
Those
actual
numbers. In other words, what I did was that to make it simple, what I did was I took a case I have and I said, this is what he makes. This is what she makes. And the gender doesn't matter. And that's what I did to get the numbers. I didn't want to muddy the waters by including any of the other deductions. So standing by itself, what is the impact? It's about 3.8%.
Representative Scher.
I'm a little confused. In your bill, it says if a self-employed obligor, 50% of actual self-employment, and Medicare taxes. It does, whereas for the employee obligor, it talks about Social Security and Medicare taxes. Why is the word Social Security not in the self-employed obligor?
That may be an error in the bill. Let me take a look at it, but clearly it's meant to, okay. It says if self-employed obligor, actual self-employment tax and Medicare taxes, and then if an employee obligor withheld for Social Security and Medicare, if we need to amend it, I'm happy to do it.
Thank you.
Representative Raymond.
Thank you. I'm curious if there was any research done to how the determination was made for when these forms first came out, because they were rewritten in 2018 based on changes that the legislature made, and then they were rewritten last year based on changes that the legislature made. And I'm curious if you, Representative Markell, know, or if we have committee research about why this was omitted both of the last times these forms were changed. I'm also curious if there's going to be a fiscal note, because I don't know how expensive it is for them to make new forms.
Well, what I did was I used the New Hampshire Bureau of Child Support online calculator to do that. That's what prints out when I did that. Child support worksheets do vary. They do have some standing orders attached to them when they print out. But this is to illustrate how it helps a little bit.
So my only answer to you is a quick answer, and I mean absolutely no disrespect whatsoever. Things like these forms are always a work in progress, and that's why we change them as often as we do, because we find things as we go that we have not incorporated. So that's my only thought on the subject. You're welcome. Representative Rice.
Thank you, Madam Chair. So I'm just trying to clarify this. What this is doing is removing the Social Security and Medicare monies that are removed from someone's pay, removing that from the from consideration for child support.
What it does is that it adjusts the obligor's child's adjusted gross income down a little bit, not a lot. In and of itself, it does not make a radical change. It's about 3.8% based on those numbers. That was, remember, and every case will be case specific, so you run them through the computer, and that's what I got.
Representative Love.
Thank you for taking my question. As all these questions have come out, I'm back to confused again over this. Adjusted gross income means gross income less 50% of actual self-employment tax and Medicare taxes if you're self-employed. If you're an employee, you get 100%. That sounds awful discriminatory to me.
Well, no, because the employer, self-employed, basically, as I understand, I'm not a tax law expert, but as I understand it, if you're self-employed, you are allowed a deduction for yourself. What comes out, as I understand it, Social Security, the employer pays a portion of your Social Security, and then you pay a portion of your Social Security. All this does, and if you look at the current way it's calculated, there is no provision for Social Security or Medicare in the adjustment for an employee. There is an adjustment for self-employed, but not Medicare, just FICA, okay, for self-employed. So what we're trying to do is even the playing field a little bit. And I think that will help. And remember, it's basically to work complementary with the advantage that the obligee gets, because the child support the obligee gets is absolutely free of taxes. So you're writing that off, and the obligor doesn't get any benefit at all. So this does not unduly penalize an obligee. All it says is that we're going to recognize it. And obviously it has to be seen in the totality of the circumstances. when you look at the other adjustments to income. So for example, when we look at mandatory retirement, clearly that's usually for something like state employees where it's just mandatory, they have no control. Same way here, okay? The employee has no control over Social Security and no control over the Medicare benefit that they have to pay. They are not able to control that. They can't say, I don't want to pay. It's not discretionary.
Follow-up?
Follow-up?
I would argue that a self-employed person would be in the same boat. You have no, I can't tell the IRS and Social Security to get out of here. I'm not paying it.
Are
Okay,
you,
and
are you asking a question,
the question
Representative?
is, why isn't it 100%? If you're going to give 100% to one, you should be giving 100%. You should be giving more because the self-employed guy is paying double.
No, what I'm saying is that the employee is, as I understand the law, sir, the employee, a Social Security withholding for an employer and an employee is a shared obligation. The employer pays a portion of the Social Security tax, and the employee pays a portion of their FICA tax. That's how I understand it. So what's not reflected here, so if we make it 50% of the employee's Social Security, that's where I think it is. It may even be slightly less. So what we're trying to do is give them a benefit.
I still don't see it. I still see a self-employed is paying double. Okay, they're paying the employer end of it and the employee. Okay,
Right.
you've got to pay double.
The
Okay,
employee, okay, well, I'm self-employed.
Yeah.
And when I do my taxes, I think it's whatever it is, SE, and I get a credit back on my taxes because I send in my estimated withholding.
Mhm.
And then I get a credit back in terms of it. The tax thing calculates what it is. So in other words, I only pay half of mine. So you're getting a credit here for half. That's my understanding of the situation.
For child support.
Well, not child support, that's for my taxes.
Well, what we're talking about here is child support, and
Representative, you have a follow-up question?
yes, I do. We're talking about child support here.
Correct.
Okay, and a 50% for one person
You're right.
and 100% for another.
Well, 50% is because you're doing your own taxes if you're self-employed and you get that credit, so that's 50%. It's not
It's still
100%.
50% you don't get. You don't put it in your pocket.
Are you arguing, Representative?
Yeah, I'm making a point.
Okay.
Okay. We're only to ask questions, Representative, with all due respect. Thank you. Representative Pearson, do you still have a question? Does anybody else have a question? Thank you, Representative.
Thank you.
You're all set?
Thank you.
The next card I have is Mary Kruger. She's asked for 3 minutes, and that's what she gets. Welcome again.
Thank you, Madam Chair, members of the committee. Mary Kruger, an attorney with New Hampshire Legal Assistance, statewide nonprofit. We represent low-income clients in civil cases involving their basic needs and safety. I'm here to oppose HB 1225, mainly because this would create maybe inadvertently sort of a double dipping situation. When you look at, and it would lower the amount of child support ultimately that someone is entitled to get as a result. Under the Bureau of Child Support Services guideline calculation, what they do is they combine both parties' income together in order to determine how much child support is due, if it's going to be due, by the obligor or payor. And when they do that, they then reduce that amount. So both of the gross incomes of both parties by calculating what the federal taxes, Social Security and Medicare would be, so that it gets deducted there in the calculation for both incomes. And then that net amount is what's used to calculate the ultimate child support. So what this would do would give the payer, the obligor, a deduction up front so that their number, when it's put into the calculator, will get a second deduction. So that's a technical thing that people should understand because it would create that situation unless you changed the formula itself to correct for that. When we hear about this being non-taxable income to the person receiving the child support, when you look at that calculator that you have, you'll see on both sides the amount of child support that each parent is sort of responsible for. And if someone's going to be paying, that's what they pay to the other person. The person who's receiving it's also responsible for a certain amount of money that they are making and earning and getting taxed on as well to support the children. So it's for both people. So if you want to keep it fair and equal, don't make this change. Thank you.
Do I see any questions? Seeing none, thank you very much.
Thank you.
With that, we will close the hearing on House Bill 1225. Thank you all. So, although the hour is early, we will be back here by 1 o'clock. Go have a nice lunch, enjoy it, relax. We'll have a lot to discuss later on. Thank you. See you at 1.
I'll support that recommendation.
Wow. Representatives, I need your advice on something. This is an join their group.
That's terrible.
Wow.
I want to point out to the chair that I changed the sign without prompting from Representative Georges.
I believe the correct phrase is without adult supervision.
Is that a chronological adult?
It is as assigned to you when you turn 30. Oh, by the way, on the matter we discussed, the wisdom is we will not proceed with this until next year. Yeah, I think so. We will. It'll also give me a chance to look to see what other states do on that issue.
Do we have that on the record?
Mayor, she's the mayor
Good afternoon.
designate.
It is, the hour is now a little after 1 o'clock. It is actually 1:01. We will open the hearing on House Bill 1228, and the chair recognizes Representative Markell, who is the sponsor of the bill. Thank you, Representative Markell. Go. You have 3 minutes.
Thank you, Madam Chairman. Pleased to introduce this bill today. What this does is that this fills a gap in the law. Last year, this committee may recall, we had House Bill 320, which closed a gap in the law. The gap was that there was no obligation on the part of any court, on the court to enforce any of its orders. In essence, a refusal to support, and I'm not talking about a contempt, which is an entirely different matter, which is discretionary on the court. This is a court could simply decline to enforce its orders, and it basically leaves and it doesn't even really need to have reasons why. And you basically, for all intents and purposes, it's unreviewable. What this proposal here does is to basically fix the same hole in the law when it comes to alimony. Right now, it's entirely possible for somebody to have an alimony award and have a court simply walk in the door and say, I'm not going to enforce it. And that's what this closes. I'll take any questions.
Wow, that was fast.
Thank you.
Thank you.
I am impressed.
I'm way impressed.
I'm amazed and mystified.
Oh, I'm sure you are. Okay, any questions for the representative? Representative Corzine.
Thank you, Madam Chair, and thank you for answering my question. My only question when I was reading through this bill was, will this stop any like handshake type deals between the two?
No, you have alimony orders. So if you have a written alimony order and that's the order, bear in mind, courts can issue orders one of two ways. They can issue them in writing or they can issue them orally. If it's done in a public proceeding, obviously there's a transcript and a record. On the other hand, if it's done in writing, and typically alimony orders are typically ordered usually in a narrative, which a court issues its order, or it's usually done pursuant to a uniform support order. Either way, if the payee or the obligee is not getting paid, there's virtually no remedy. We need to plug this hole.
Follow up?
Would this bill make it so that a man and a woman can't come to their own decision? Like, let's say the guy's sick, and so the wife says, "Well, don't worry about alimony for the next month." Would
Okay.
that stop this? Would
The
this stop?
concise answer is that alimony orders are enforceable as they are. And the only way you can truly modify an alimony order, truly, is by going to a court and having a court-approved modification.
Representative Rice.
Thank you, Madam Chair. Thank you. So would you say that the only reason this would go into effect is if another party brought a complaint?
Correct.
So it's not like child support where it's automatically taken out of your paycheck?
Right. Well, alimony orders can go one of a few ways. They can be withheld. They can also be typically. They also are usually paid by payee, payor to payee, or they're usually done by bank deposit. But they can be by wage assignment. So you can do that.
So then to
Follow up?
may I? So then to follow up on what Representative Corson said, if there was an agreement, but they had garnished wages,
Mhm.
would this then say someone is sick and out of work for 3 months?
Mhm.
If they go back to court, if they end up back in court because someone other than the person receiving it brings forward a case, would that then negate their personal agreement?
Okay. Well, what you would end up doing is that a personal agreement is a personal agreement and it's not enforceable unless it's a court order. That is a general proposition. So you might hear somebody say, well, he and I, she and I, whomever had an agreement, they wouldn't do this and they wouldn't do that. Then you could bring that to court and seek judicial enforcement of it if a court was to exercise its discretion and do it that way. If you were to seek enforcement on this, you can obviously, this is a situation where you would file, unless modified an agreement to the parties or pursuant to RSA 458-19AA. So in other words, if you had a problem and you couldn't and you were behind and you needed to modify it, you can certainly get judicial approval to do that.
Representative Raymond.
Thank you, Madam Chairman, and thank you for taking my question. So my question is about how this will change the procedure. So right now, if someone is not receiving their alimony,
Right.
can they go to court? Like, can they file in court to have the order enforced? Or
Yes, you can.
so what does this give them that they don't have now?
This basically significantly curbs judicial discretion. And if a judge says, it's not going to enforce it, go ahead, not going to do it.
Does that follow up? Does that happen?
Yes,
Can you give some examples?
not
of, like,
without
why?
breaching client
No,
confidentiality.
but I mean, like general circumstances, why a judge would just be like, oh, too bad, I made an order, but we're not going to follow it. That's so
It's whimsical.
unfair.
Well, we may have heard about complaints about ending the family division. And while I did not support that, and I still don't, nevertheless, this is a remedy, I think, that should be available to a plaintiff who's either represented or either self-represented or has an attorney. It's a hole in the rules of court.
Thank you.
Representative Scher.
Thank you, Madam Chair. So in that example, even with this, what you propose in place, so the judge under this can't say, I'm not going to enforce it, but couldn't the judge just say, all right, sua sponte, without anybody asking, I'm going to change the alimony order?
Can't do that. Has to be properly pled.
Thank you.
Representative Gregg.
Is that me? Okay, I was like, so I just wondered, obviously this is a contentious court. Oh, thank you, Madam Chair, and thank you for taking my question. Forgot my manners. It just says past due amounts of alimony shall be enforced. Is there any reason to like identify an amount or a certain like percentage, or is this something that can be weaponized? Like, oh, you're, you know, a day late or something, I'm going to take it back to the court and have this enforced, because obviously we know that this particular court is incredibly contentious. So
Yeah, yeah. Well, what you would need is you would need to enforce an order. You would need a specific dollar amount or a specific, or you would need something that could be made some certain. So if it was a
but it could
percent,
be
so
any past due amount.
it could be, yes. Obviously, you might be, there's somewhat judicial discretion. You know, for example, and if the amount is paid, and you know, obviously, then the answer would be dismiss points moot. But and I would think that a court still has the discretion to award attorney's fees to somebody who, you know, is a vexatious litigator or basically abuses the system.
Seeing no more questions, thank you, Representative.
Thank you, Madam Chair.
I do not have any further pink cards. So I will close the hearing on House Bill 1228. And Representative Markell is really, really, really smart to stay right in that chair, except I need another pink card.
Is it time? No, we can't start the next hearing until 1:30.
So Representative Markell's going to fill out his paper, and Representative Scher, were you reminded to do that, Representative?
I was not.
Oh my God, 2 in a row. I can't even stand it. He is. I should, I Representative, yes, remember those? Representative, I do have a fireball.
No need,
So the next hearing is going to begin at 1:30, so we have a little bit of a break. It is 1:30. We are scheduled to open House Bill 1229 relative to waivers of alimony, sponsored by Representative Markell. Representative Markell, you have 3 minutes.
Thank you, Madam Chair, and thank you to the committee for listening to my bill. The reason for this bill is a couple of things. First of all, society has changed in a lot of ways, and agreements, the nature of alimony has changed, the workplace has changed, and a lot of different things have changed in society. The purpose of this bill is to be able to give full force and effect to alimony agreements that are validly formed, because it can help settle cases. And let me explain what I mean by that. First, let's review the bill. It says that agreements in which parties waive any and all rights to past, present, or future alimony, or any portion thereof, shall be given full force and effect unless the agreement is found by a preponderance of the evidence to be invalid, and then we cite a number of reasons. And they're basically barriers to contract formation: coercion, deceit, duress, fraud, mutual mistake, material misrepresentation, supervening illegality, or where such enforcement would be unconscionable. In this particular context, unconscionable means basically something that would shock the conscience if they were to try to enforce it. It would be fundamentally unfair and unjust. So in other words, this bill has the flexibility to be able to say, okay, as a general proposition, we will give force to an alimony agreement of the parties, except where to do so would be fundamentally wrong. Now, this would be probably a change in social policy as to New Hampshire. For example, back in, I think it's 1992 or 1994, the Supreme Court decided in the case of Norberg versus Norberg that waivers to future alimony and things like that were fundamentally unenforceable, and that they weren't going to do it, and that the court, even with the circumstances as they were unforeseen, where you're not going to let that kind of thing happen. Now, interestingly enough, if you look at the handout that you have in front of you, which is a blank proposed final decree, that's printed by the New Hampshire Judicial Branch, and it's used basically as a template for parties to be able to form their own final decrees. The interesting thing to note about it is on page 2, and if you look where it says paragraph 6, it says alimony, and it says see attached uniform alimony order, or you can check NA. Now, bear in mind that this form was changed because before this, it used to be in the pre-printed form that parties could agree to waive, could more or less agree to waive alimony on the condition that the other party would have, the party seeking alimony would have to defend or indemnify the other party against the claim of alimony, therefore basically voiding it out. That is no longer the language that appears in a final decree. So what we're looking at is a change of policy. Bear in mind the following. Number one, the legislative branch changed the fundamental policy of alimony because the primary purpose used to be for rehabilitative purposes. Now it's for both parties to maintain a standard of living. Now, that's a profound social policy change. Now, carrying that one step further, what we have are prenuptial agreements which do settle cases, and they do provide predictability of a result. The one wild card sitting out there in New Hampshire is alimony, because you can't waive that. Now, there are certain things you can't put, other things you can't put into a prenuptial or postnuptial agreement that will be enforced, which will be things like support for a child or child custody. Child custody or child support. We understand that because they serve completely different purposes. But what you have here is a situation where somebody can literally buy somebody out, okay, of a claim to alimony, and then have it, frankly, turn around and come back and bite them in a good faith representation later on, because it came out that we weren't able to waive it. So you can never truly settle a case. Unconscionability, for example, might be something along the lines of Getting catastrophically ill, not your fault. Getting involved in a car accident, not your fault. Somehow you end up in a wheelchair, not your fault. For other reasons that are probably not your fault, for why you can't become self-supporting. So the court still, in that respect, retains jurisdiction. And notice this only applies to agreements. Courts are always free to scrutinize the agreements to make sure that they meet certain criteria that the court may want to have. Now, for example, in Massachusetts, for example, these kinds of agreements are binding. In Massachusetts, you have a similar thing. What they have is the doctrine of separate and merger. In New Hampshire, in Massachusetts, I'm sorry, is where that is. Things that stand separate include alimony contracts to either make it a specific amount or waive any past, present, or future alimony, or to limit it. Courts in Massachusetts, for example, will give that full force and effect. The doctrine of merger would mean that if they put it all in the decree, it would have no independent legal significance. So what I'm suggesting is that we update our laws, and this does not impede the ability of any party to seek alimony. You can go to court and seek it. If you come to an agreement, it's modifiable if you come to an agreement. And but this is agreements that have to do with alimony, if you see what I mean. Because if you're doing an agreement in court, the parties can always agree that this is modifiable. So in other words, you're not boxed in. Okay? I'd be happy to take any questions.
Representative Petrino.
Thank you, Madam Chairwoman, and thank you, Representative, for taking my question.
Sure.
I'm just wondering, what would be the interest of one party to waive the opportunity to receive alimony? Why would someone want to do that?
For example, supposing we're dealing with a very wealthy couple. Supposing somebody says, I'll give you a substantial piece of property or a substantial amount of money in return for which you agree to waive alimony. So let's say with Elon Musk or Jeff Bezos, and he says to his wife, you're getting $50 billion. I'm asking you for an alimony waiver. I think in exchange for you might otherwise get $10 billion. I'd like to be in that situation, but where you get $10 billion, that would be substantial consideration.
Quick follow-up?
Follow-up?
Thank you for that answer. That
Sure.
answered my question very, very much. My next concern is the matter of individual being coerced. okay?
Correct.
The preponderance of evidence seems to be a bit high. How do you using the preponderance of evidence to prove that someone was in fact coerced?
Okay.
Or maybe they didn't have knowledge what they were signing a waiver and they weren't aware of the consequences.
Right. And those are basically, and you're asking a good question, sir. Thank you for it. That's basically a defense to contract formation. Coercion might be something in the form of, if you don't sign this, I will, and then fill in the blank. Sign this or else. Or, for example, we're going into court like the night before or whatever, and sign this. So that would be a good defense. These kinds of defenses are well understood. And these kinds of things are well understood in contract law. And they're also pretty well understood in family law as well.
Representative Gregg.
Thank you, Madam Chair, and thank you for thank you for introducing another bill. Sorry, I'm tired. Lunch hit me hard. Have you thought about putting in any procedural safeguards? I know that in other states under the Uniform Premarital Agreement Act,
Yes.
they have some different safeguards, like a waiting period or requirement that both parties have counsel to make sure that there's not undue influence or that kind of advantage.
Very good question. And I actually addressed that in an opinion letter for a South Carolina court regarding a case I had where there was going to be an enforcement of a New Hampshire prenuptial agreement where the governing law was going to be New Hampshire. New Hampshire is not a signatory to the Uniform Prenuptial Agreement Act. And so our prenuptial agreements are more or less judged on an individual basis. Each one stands or falls on their own merits. And if you want to have a good prenup, there are certain things you should follow. And, advice of counsel, Both parties should each have their own counsel. Both parties should each have their own competent counsel. If you wanted a redacted copy of an opinion letter I did for a particular client, and this has nothing to do, just as an example of how you can draft an opinion, just how you can draft a prenuptial agreement, that's available with redactions. And those are the kinds of procedures you should follow to make sure they are not set aside. So they have to be free of coercion, duress, and everything else.
All set? Representative Scher.
Thank you, Madam Chair, and thank you for your testimony. A question. Before the New Hampshire Supreme Court got rid of alimony agreements,
Right.
they decided a case, I think in 1989, a case called McFarland versus Rich,
Yes.
which gave 3 factors for when the court would be resistant to disposing of prenuptial agreements about alimony.
Yes.
One of them was what you contain in your bill. The agreement was not obtained through fraud, duress, mistake, etc.
Right.
Second was the agreement is not unconscionable. That is also in the language of your bill. The third one is the facts and circumstances have not changed since the agreement was executed so as to make the agreement unenforceable. That language is not in the bill. Would you be amenable to an amendment that would add that language?
We could, however, we could certainly put that in there to render it unenforceable. I would view it synonymously with unconscionable. That might be something where, unconscionable is shocks the conscience of the court, is shocking, unjustified, unjust, are basically those terms.
Follow up.
Sure, follow up.
The court had that factor separate. I think the third factor, the facts and circumstances have not changed since the agreement was executed. Doesn't that really focus on something different than, as a matter of policy, the unconscionability of the contract?
Well, it kind of does, and that's a very good point, sir. I appreciate it. If the facts and circumstances have not changed, which you would, that basically forms the underpinnings of property, the underpinnings of a property settlement, which are generally not modifiable in the state of New Hampshire, unless these types of factors are in there, or unless the parties agree to a change in a property settlement.
I guess one more follow-up.
One more follow-up.
So if I were to file an amendment to this bill that added that language, would you have any problem with that?
No.
Thank you.
Sure.
Seeing no other questions, thank you very much.
Thank you.
I have no other pink cards. I'll close the hearing on House Bill 1229. The next hearing does not begin until 2 o'clock. We have 15 minutes. We're doing great. So you get to have another break. I'll now open the 2 o'clock bill, House Bill 1779, supporting the cultural background of children placed in foster care. And at this time, I'll call on Representative Mary Georges to open and introduce her bill. You have
Thank you.
3 minutes, dear.
I'm not going to make it those minutes. I just put it. I just put it just on the paper, but I'm not going to make it those minutes. Yeah. Thank you, Madam Chair and member of the Committee of Children and Family Law. Thank you, ready to have me for today, to be here before you. I know it's my first term and my first time to present, but this is my second one to present. Yeah, I stand before you with a deeper sense of purpose to introduce House Bill 1779 FN, a crucial pieces of legislation that honors and preserves the cultural background of children placed in foster care. As we know, children are the heart of our communities and the future of our society. However, many of these children face significant challenges, often uprooted from their homes and placed in an environment that may not reflect their unique identities. Research has shown that understanding and embracing one's cultural background is not merely a matter of personal pride. It is a fundamental aspect of emotional and psychological well-being. Imagine being a child taken from the only home you have known and placed into a foster home where your cultural tradition, language, and the value are unfamiliar. The impact on a child's development can be profound. In contrast, when children maintain a connection to their cultural heritage, studies have demonstrated improved emotional health, resilience, and the overall outcome. This is not about preserving culture. This is about enabling children to thrive. New Hampshire has a strong foster care system that ensures children receive the care they need when their parents and other family members are unable to provide it. This bill will strengthen our foster care system by ensuring that children receive culturally sensitive and appropriate care that respect their tradition and heritage.
30 seconds.
Okay, the bill seeks this. Ensure cultural competency in foster care. We must implement a training program for foster care providers, equipping them with the tools to understand and respect the diverse cultural background of the children they serve. Promote inclusion of cultural practice. The bill calls for the incorporation of cultural practice and the celebration into the daily lives of these children, enriching their experience and helping to foster a sense of belonging. Facilitate family and community connection. We will work to strengthen tie between children in foster care and their extended family members and community resources.
Are you almost done, Representative? Your time is up.
Okay.
Thank you. Do we have any questions for the representative? Representative Raymond.
Thank you, Madam Chairman, and thank you for taking my question. I really like this piece of legislation. I'm curious about what falls under the umbrella of maintaining their cultural background. Does it include things like bringing the child to religious services that they would have had they stayed at their home of origin?
Can you
Like, does it mean that if I'm a foster parent getting a child, will I now be required to take them to church services that align with the child's belief as opposed to, say, my own personal church?
you can take the children for your church. It's not it's not something like something is here like when we talk about the background, there is a lot for things for background.
Yeah.
That where the kids can be like a be out. But like a children, where you go to church, you're gonna go with the kids because the kids live with you. But the thing is too, if that kids come from another church and the way they pray, the way they do this, you can too allow the children to go to that church. Is okay because that way, if you can feel if you can feel very good, that is the way to the is a dependent. But if you like those little kids, it's okay. But the young kids who are already knows where to go to church, how to pray, you can take him to another church. But depending if she say I'm gonna go to that church, you can let your child go to that church.
Follow up? Follow up. So it sounds like there would be some training for foster parents and DCYF workers about navigating how to maintain those connections as opposed to like a mandate.
They cannot be amended.
Okay. Thank you.
Representative Corzine.
Thank you, Madam Chairman, and thank you for being here to answer my questions. I love the thought behind this bill. I think it's very important. Like you, I agree that kids need to take pride in their culture. I do worry, though, that this bill almost gives those children a right to their culture, which in New Hampshire is going to be very difficult to maintain. It will, I believe it will stress the foster care system. I believe it may even cause some foster parents to not become foster parents. What is it that you were looking to do with the bill?
I just can speak about this because I've been as a leader in community and as a leader in the community and somebody who come for another culture. And I know I've done a lot for integration, how to help the children to integrate like to the new culture. And I know I have that idea like a curriculum, like they say cross-cultural. I know the kids come from another culture, here there is another culture. When they merge both, they become three cultures. Now it's dependent which one the kids gonna embrace. But the problem is how you gonna make a children to take that culture. How she can just be stand with everything, because sometimes the kids feel really like they are lost. You see, they can children can look like they're lost, but we need to help the children because we are talking about the children. We say here we are here for children. We are here because for the first thing to how we can make those children for the future. And this is where I'm worried much because that always be like my advocacy or my help that I try to make like kids to look good, to not be lost.
Representative Love.
Thank you, Madam Chair. Thank you for taking my question. I like the idea of training. You know, we don't have enough of it in a lot of different subjects that we have to deal with. I do have some concerns, you know, as far as like somebody mentioned a mandate. I don't ever want to see this turn into a mandate because that we have a lot of different cultures, and you know, how are we going to get training for 30, 40, 50 different cultures, all, you know, and have it so specific. I also like to know who's going to enforce this, and would would you be okay with amending this, saying this will in no way ever be used to take a child from a loving home, a good home?
Representative, can you ask one question at a time? I heard three.
You did. I only asked one. I made statements,
Okay.
and I asked one about the amendment.
Okay.
Would you be okay with amending this to say that this in no way can ever be used to take a child from a loving home?
Don't take a child to the loving home like to their parents or loving home like
A foster home. I know of an instance where it's happening right now.
if there is a problem at the home. At the foster home.
I don't understand.
Yeah, I didn't understand.
I'm having a hard
your
time with
question.
your
I didn't
accent.
understand your question, but I say when Representative Raymond asked a question for mandated, I say no,
Yeah.
it's not be mandated. But what I can say for children, I'm talking here about the children because I saw children living in place. I can give example for two girls. One of those kids, they came. There is a one came before, in Lee here in New Hampshire, but she couldn't stand, and they bring her back home. But there is another one who came, the girls, having a problem, but they was looking for. They started looking for the family from Congo, and as the leaders, they came to my attention, and I told them, bring me down, let them. I would like to talk to them. The family came to my house. We talk. We share everything. They explained to me. There was a lot of things what they was explained to me about the child, and some stuff it was not really something bad, but for them there was things so is a bad, and I said no. Where they come from, their culture is like this in our culture, and especially where that girl came from, they really they don't really like to talk. Especially like even if the father's talking, he need to be like a bow down. And there was a lot of things. And after they came with the girls, I would like them to bring me the girl. They came with the girl, we talked. But I didn't have a chance to talk to the girl. The girl left. They went both, all of them. And another day they sent me a message. They said to that message, I think so we're gonna just bring her back. I said, no. Can you guys bring her? Let her stay with me at least for the weekend. And they sent the girl stay with me for the weekend. I think so that girl finished school. Today she's a really but she went to 3 families. You see that? She was going to 3 families, but all those 3 families, they're gonna bring the report to me. They're gonna talk, she's gonna stay with me. I'm gonna be with her. I'm gonna help her for the hair. Even for my program. Today she's really is an executive director, I think so, for the adoptive place, in Maine. Why? Because, she have all of those, there is a lot of things. Sometimes the way she's acting or what, that you can understand about to have somebody who helping you about the culture. Why she's supposed to do that, but it was not easy for her. That's what I can say. But she went at least 3 home, changing 3 home empty before to finish high school. It will always be like my daughter. I have a lot I can say about those changes.
Thank you.
Representative Pearson.
Thank you, Madam Chair, and thank you for taking my question. I'm a co-sponsor of this bill, as you know, and I come from a multicultural community in Massachusetts and saw how advantageous the honoring of different cultural backgrounds was, especially when various placements were needed. But here's my question. I question the need, according to the fiscal note, for expending in 2028 and beyond over $1 million a year to hire cultural advocates. When 50 years ago, I saw people of various cultural communities do this work as concerned volunteers. So my question is can the heart of this bill, and I hope it's true, can the heart of this bill be fulfilled without paid professionals?
This is the way you guys know how they implement the work. But I can say I did it for free.
Yeah.
I did it as a volunteer. But what that was for me, it was like it's not even I can say for that one. I have another one I say is a family from Congo too, but they have 2 girls, 2 kids, 2 boys, young boys, 1 2 years old, 1 5 years old. He was in the DC. I went to visit. When I went over there, she had those 2 young 2 kids, and the way she was feeding them, the way she was treating them, the way she was with them, and they're white kids. She didn't know what to do, and I just look myself. And first of all, too, she never have a kid for herself, and I look just the lady with those kids. I said, "How come you're gonna give her this?" The first day I said, "How you gonna give her this food like this?" She said, "Oh no." And what I said, no. But after that, myself, I went to the store with the first parent. I buy the food. I start to show them what kind of food you can make for those kids. Not just giving them those food all the time, but you can buy. I bought like those packets of macaroni and cheese that will already make it. You can just easy make it. How you can make this? How you can make all those things. I just try to teach. And I buy the stuff, the soap, like the shampoo, like all the body wash. I start to teach them what to do for all those. It's just to help. We need to training. Because they are children. They don't even know, and we need to put the kids to feel comfortable, to feel ready to thrive. They are children, and we need to help the children. I help them even here at Central High School. I do the program. We help the children, but it's not just. But with the program, if we don't pay, if they don't train, but there is those working with the cultural organization too. That is a way how we can train, how we can help, because we have like the domestic violence, like a cultural domestic violence. With the cultural domestic violence, we learn, we teaching. I always go in conference for like it's a national conference. We always see culturally. We are there, the Hispanic, the Asia, everybody, but they are learning. We are training how to help or how to make this, how to do this for domestic violence. We can make that too.
Thank you. Representative Raymond.
Thank you for indulging me. Representative Pearson made me think of a question. And my question is about whether you think that instead of hiring a bunch more social workers to kind of do this work, if DCYF could create contracts with existing cultural resources, like in Nashua, and I'm sure Manchester has it as well. We have a cultural connections committee through our city government. There's also, big roundtables where all of the, social work groups get together. And I'm wondering if you think that there is room in those spaces to create contracts to provide this kind of training to foster parents on, things like how to do hair and where you can go to learn how to cook and those kinds of things, as opposed to hiring a bunch more social workers to learn that and then travel out.
Yeah, that is true, and also to hire them, because in my organization, I just work with all kinds of languages. But I don't myself. I know I speak how many language myself? I speak six language. I have another one speak another how many language, and I hire people who speak those language, or hire people who are for culturally. You can hire them too, because if you hire that one, can help all the kids too, can do something. This is what I can say for my organization. Why with the Victory Women, if you are really like a most unique, but because we have a people who can speak all kind of language. When somebody come at the door, you're not gonna feel really like a embarrassed, because you're gonna find somebody who's gonna speak to you, who's gonna listen to you, who's gonna understand you.
Thank you.
Follow up on that?
Sure.
And isn't it true that DCYF already is obligated under the law to provide those kinds of translation services to families when they need someone to speak in their native language instead of English?
We talked with the DCYF. I was one of, they was implemented, was to do like a session or what. I was with the DCYF. I was one of them to, when they call it like a leaders who can speak about culturally and what is going for how to help the children. I was there. We talked. We explained too how they can navigate with to do all the kind of work with those cultural children.
Thank you. Any further questions? Seeing none, thank you very much, Representative.
Thank you.
I'm going to go out of order a little bit. I'm going to call on Marie Noonan and Susan Larrabee from DCYF because they're here to answer questions. Normally, I would call the next representative, but I know there's a lot of questions from the committee, and maybe these two ladies from DCYF can help us out. Please introduce yourself, and then I will call on the first question.
Good afternoon, Madam Chairperson. My name is Susan Larrabee, and I am General Counsel and Legislative Liaison for DCYF.
Good afternoon. My name is Marie Noonan, and I'm the Division Director for DCYF.
Thank you both and welcome. I don't think you've testified before us yet this year, so this is a treat. The first question I see is Representative Rice.
Thank you, Madam Chair. Thank you for taking my questions. I really like this bill, but I have some concerns. One of them is recruitment and retention and how this would affect that. And also, does DCYF already take into consideration the cultural background of the child and try to place them in the appropriate homes? Is that current practice?
Yes, it is. So currently, DCYF certainly strives to place children in the most familiar settings. We do the best we can to match children's needs with caregivers who are available to meet those needs. We also are very focused on having children placed in kinship care whenever possible. We have a new law that passed that allowed for a kinship license, and you may know that kinship care involves caregivers who are either relatives or people known to the child or family, such as teachers, coaches, someone from a church community, someone from a local organization that the child and family knows. So in that way, we try to maintain the child's identity and culture and also have them with people who are familiar to them rather than foster care settings. But yes, in any instance, we try to maintain as much normalcy and cultural norms as possible as we place children in care.
Follow up?
And could you address the recruitment and retention part? I'm a little concerned that people will be like, this is just too much and I'm not going to do it now.
So we do already train our foster families in cultural awareness and cultural competency and wanting to be able to have them understand the specific and unique needs of any child placed in their home. So that kind of training already does exist today. In regard to whether this would prevent a family from coming to DCYF's attention, I suppose that's possible. Someone may choose not to apply for foster care, caregiving for any number of reasons. But again, we already do train families in our desire to have kids maintain their cultural identity.
And if I could just add a little bit about that in terms of context. So as you know, in 170E34, the department has rulemaking authority to establish the standards and requirements for licensing of a foster parent. And that is through HEC 6446, Foster Family Care Licensing Requirements. And within the robust steps that it takes to become a licensed foster parent or foster caregiver, there is HEC 6446.21, religion and culture. And if you don't mind, I'll just read that. That says that foster parents shall respect and encourage the linguistic, ethnic, religious, spiritual, and cultural background of the child in care and of the child's family. Foster parents shall cooperatively support the child in care in maintaining his or her linguistic, ethnic, religious, spiritual, and cultural connections. And that same requirement is also in our kinship care licensing standards in 6447.22. And as Marie further talked very briefly about, we have pre-licensing training, which is required for both kinship care licensing as well as foster care general licensing. And that is for the general licensing home, a 30-hour robust set of courses, trainings, administered by our training partners, CWEP, located at UNH. They have adapted the curriculum for the national standards of the AFC, ACF, our federal partners, the Administration of Children and Families, that have a federal national training database. It's called the National Training and Development Curriculum, free curriculum, which is always great, that we have adapted and made it look New Hampshireized. And within that 30 hours of training includes Module 4, which is entitled Supporting Children's Social and Cultural Identities. I could go into more about the learning outcomes, but I want at this point, if there's any questions about that.
Representative Raymond and then Representative Petrino.
Thank you. I have two questions about that. And the first one is, if a foster family wants extra support doing things like learning about hair and skincare or learning about different foods, like because they've never made, say, Indian food before, what resources does DCYF provide to those foster parents in those, case-by-case situations?
So we do have curriculum where we work. We have a parent partner program, which expands to working collaboratively with foster caregivers and kinship caregivers as well. And so through that group of professionals, there are a number of networking opportunities that happen across the state where we partner with local agencies, local community groups, local stakeholders in order to hear from community members and be able to match anyone's needs with a resource that might be available in a local community. Additionally, we have a collaborative relationship with the Department of Health and Human Services Office of Health Access, which also works very collaboratively with local community groups, refugee agencies, other kinds of grassroots organizations where we can connect families, our staff, and local community groups together in order to meet the needs of kids, caregivers, whatever the entity may be.
You have a follow-up?
Yes, thank you so much. So my second question is, if you have this network, there's a hefty fiscal note with this, including 14 new case aides. So what would those case aides be doing?
So in the bill is the requirement for each child to have a specific advocate, a cultural advocate who's a trained professional. So in order to meet that requirement for every single individual child that comes into foster care, we would need to be able to hire and train those professionals to have the skills and requirements set forth in this bill.
Thank you. Representative Petrino.
Thank you, Madam Chairwoman, and thank you for taking my question. Representative Raymond did ask one of the concerns that I had regarding the fiscal note, so you did answer that. But it does sound like an awful lot of what the intent in this legislation wants to do is already taking place. Do you see that if this legislation moves forward, it would affirm the work that you are currently doing?
Certainly, it would elevate that each child would have a specific advocate tailored to their specific cultural needs. Certainly, each child that comes into foster care is assigned a child protective service worker who serves in that case management role, is responsible for the oversight of that child and that parent's needs, which would include the cultural identity and ensuring that kids and families receive what they need. So I think if we were to implement this bill and have the additional 14 staff and a supervisor that we would need to incorporate it, it would certainly elevate identification of those needs and trying to meet those needs in the community-based settings. Again, some of it would be a bit repetitive, whereas we already train foster caregivers, we have an assigned caseworker, but it would have a dedicated focus.
Representative Chair.
Thank you, Madam Chair, and thank you for taking my questions. I think as several people have expressed, I think this is one wonderful legislation. And I appreciate what DCYF is already doing. I'm wondering, do you have a copy of the legislation in front of you?
Yes.
Could you look at page 2, line 7, which relates to the cultural advocates for children placed in foster care? That language currently reads, every child placed in cultural foster care shall be assigned a cultural advocate within 30 days after placement. And as you've described, there would need to be, as written, you need to hire 14 cultural advocates and a supervisor, right? Mm-hmm. So my question is, if the language instead were to read, every child placed in cultural foster care may be assigned a volunteer cultural advocate within 30 days after placement, either, and that, I turned the shall into may, but maybe the shall can stay, but to put the word volunteer in there, that would, fair to say, dramatically reduce the fiscal cost of this legislation?
I can see where one might think that. However, that would certainly be an additional ask on our current child protective service workers to be able to consider every single child in care and trying to identify a volunteer in their community.
Follow up?
Follow up?
So that might, the resources needed might be 1 or 2 additional people instead of 14 or 15, fair to say. 1 or 2 additional people who would coordinate for lack of a better word, a stable of volunteer cultural advocates.
Yeah, we would probably need to establish a program of people that are going out recruiting and again, wanting to ensure if these are not individually trained professionals, how to ensure that if there were a shall, how to ensure that our staff are able to access cultural volunteers for every cultural identity that may exist for a child, I anticipate might be a bit of a challenge.
One follow-up?
I could also maybe refer also to line, on the same page, lines 23 through 29, which talks a lot about the policy behind this bill and what we are currently doing in terms of working and collaborating with the foster parent, with the child themselves, with their birth parents, in supporting their cultural connections. I do have a bit of a little bit of a struggle with the definition with the definitions above, especially when it comes to cultural foster care, which means a specialized foster care system that seeks to place children with families who share or respect their cultural background. And as we all know, every human being has a cultural background. We all have a cultural heritage. That's what makes us all humans. So I do worry a little bit about the definition section there. And I also worry about it running afoul with the Multi-Ethnic Placement Act, in which placement of a child or placement of a child of the foster parent or the child's race, color, or national origin can't be the primary factor in how we place a child. And I just do worry about the definition section of cultural foster care and what that really means as implemented. Yes, thank you.
Follow up?
One more.
Let's go to the definitions of cultural foster care. I think you read that. Cultural foster care means a specialized foster care system. If the word specialized were taken out, that would moderate that language.
Agreed.
Thank you.
Thank you, Representative Rice. And then
Thank you, Madam Chair. Thank you for taking my question. So my question is, to kind of piggyback off what Representative Chair said, is there anything else in this that you feel is going to conflict with what you said earlier with what you already do, what's already in there, the 170E and the HC, I couldn't keep up, but is there anything else in here that would conflict with that would cause, then we'll back saying, oh, we have to fix this because we're running into this was a conflict?
Yes, we're discussing a bit, so thank you for your question. Just the Cultural Foster Care Fund and whether, if we're striking a specialized foster care system, whether the fund would be necessary.
And I had one brief other issue, foster care bill of rights, which obviously I think it probably may have come before you all in recent years, by our youth advisory board, who have worked really hard and tirelessly on this and continue to give us different ideas for adding to it. And I do want to note that under how it stands now under the foster care bill of rights, Roman numeral 5, it states that a child who is placed in a foster care or out of home placement shall be treated with courtesy and respect by department staff, foster parents, residential staff, and providers without regard to race, ethnicity, sexual orientation, gender identity, religion, or disability, and to participate in activities associated with his or her religious beliefs. And that's what exists now. This bill would add to it to live in an environment that maintains and reflects the child's cultural background and heritage. So there is a little bit of a possibility that we're saying in 5 without regard to their cultural identity, and now saying that this home will reflect their cultural background. I believe that 5 encompasses what 16 is trying to accomplish.
Representative Gregg, and then
Thank you, Madam Chair, and thank you. It's nice to see you all again. Thank you for being here, taking my question. So with our cultural, since you're already doing some of this, and by the way, I think you can see that this is definitely something, and this is a priority for us, and that's what we look for. But what deficiencies is DCYF currently having? Priorities as far as us making sure we're getting everything right for the foster care. I don't want to put motive into anybody, but anyway, what deficiencies right now do you all have with the cultural piece within DCYF?
I think we always could do a better job of ensuring that we have matches for kids and families, right? So that the whatever the unique needs of a child are, that we have a family that's able to match those unique needs, whether that's large sibling groups, whether that's a particular race or identity or religion. So we are always recruiting homes, and certainly, we talk a little bit about, what would be the right number of foster homes available. And it's not as easy as saying we have X number of kids in care, we need X number of foster homes. We always need more than the number, perhaps double the number of kids in care because of that match situation. So even if we had a foster family of every culture and identity, it doesn't mean that that home would necessarily automatically match with that kid's presenting needs or behavioral challenges or symptoms or mental health needs. And so certainly recruitment of homes remains a challenge, despite diligent efforts.
And obviously, again, recruitment of kinship care homes, especially when it comes to our children in care in which English is not their primary language. And that's why kin is so important, a family member or someone in their community who speaks their language, and recruiting and maintaining those kinship relationships are paramount to our priorities right now.
Thank you. Representative Corzine.
Thank you, Madam Chair, and thank you again. In reading the bill, are you at all worried about the litigation this could open the state and the department up to if we don't have the foster homes needed to satisfy everything in here?
Well, I think the shall language in terms of providing an advocate would be a concern if we are unable to identify, if we're using volunteer advocates, if we're unable to identify a volunteer to be able to meet a specific child's cultural identity or cultural needs, that would certainly be a concern.
Thank you. Representative Love.
Thank you, Madam Chair. Thank you for taking my question. It's just some information on what you've already mentioned. You mentioned a Foster Care Act or something that said that culture shall not be the deciding factor. What was that?
That is the Multi-Ethnic Placement Act. Sure. The Multi-Ethnic Placement Act. It has an acronym, of course, MEPA. U.S. federal law enacted in 1994 as amended in 1996 with the Interethnic Adoption Provisions, IEPA.
You all set, Representative Love?
Thank you very much.
Representative Gregg.
Thank you, Madam Chair, once again, and thank you for taking a second question. So if a caseworker right now identifies a cultural mismatch, like they're just not able to kind of meet that in a placement, what is your current protocol, or do you have one?
So we would certainly do everything to try to create an opportunity to correct that mismatch. So if we can maintain children in their placement without transitioning them to multiple placements, which can be traumatic, we would try to bridge whatever gap we're identifying. If in the end it's detrimental to the child to stay in that setting, then we would certainly look for another match to be able to meet that child's needs.
Seeing no further hands up, I don't think we have any more questions at this time, but I'm going to ask if you can stick around for a few more minutes and see if anybody comes up with any other questions. Is that okay?
Absolutely.
I really thank you for indulging us. It seems Representative Wheeler had to step out. I'm sure he'll come back as soon as he can. So the next card that I have is Shirley Harionto. I'm sorry if I'm pronouncing your last name incorrectly. Press the button.
There you go.
There you go. Now
Is
we
it
can
need to
hear you.
be red? Oh, red. Okay. Hi, my name is Shirley Haryanto. I'm a single mother of 4 years old that on the open case with DCYF. So in the momentum of this House bill, I agree and disagree. First moment, I have cultural backgrounds that doesn't have any intention of any solution about that. Many cases, I bring these concerns to my social worker. It's been neglected and discourages, and somehow I get harassed and abused by either verbally or in action. And as well as I do agree with the cultural if they can get like volunteering as long as no other funding or any more money from a federal money, because give more opportunities to people like other parties, including I'm a Christian. So I believe many Christian churches out there that they have many different types. So my recommendation is every children that been away from the parents should go to the church that they belong to before they taken away from their biological parents. And then somehow, I just don't understand with multi-ethnic placement act. So I need more knowing information about that. And for the foster care, like give an example, I asked my son, "Hey honey, have you prayed today?" And he said no. What is pray? And I said, "Can you follow, like repeating after me? Jesus, my name is Joshua," but in a different language, because I don't wanna, I'm just gonna teaching my opportunities of my culture to my son instead me speaking English, because I want him to have bilingual. I don't want him to only speak English. If he can, I wish he can speak 12 language fluently. That's what kind of mother I want him to be. And somehow, I'm sorry, I'm a little shaky because I'm cold. As I'm a little lost, I'm sorry. Can you refresh my memory again? I'm sorry, I get nervous and sit in this chair, being honest.
So you were teaching him to
Yes.
pray, yeah.
So I teach my son to pray, but unfortunately, nobody in the foster parent willing to give him any prayers. And as well as many times I asked my social worker, "May I please bring my son to go to church?" And she keep refusing. And also my progress is supposed to be progressing way ahead, but unfortunately they keep not responding to all my emails. And I'm supposed to have at least a sleepover by now, but now I have not. So before the TPR, I have 3 hours of half supervised visit every Tuesday and Thursday. But because of some reasons, the judge denial of my hard work and decide to terminate my parental rights with reasoning of me being argumentative and combative. That's not the right reason on family law for terminate parental rights. And I don't get really strongly advocate from my attorney as well. And in the moment time also, not only, I understand if it's like Halloween, maybe one day, he can dress up like with the dress, I don't mind. But somehow he came out to my visit with many days of wearing a dress, like a princess dress. It's even turning up. Like the dress is really long and I'm afraid of him to be fall down. I still have a picture. And I keep telling the parent, "Hey, please can you tell them to not put the dress?" Because this is like, my son is a boy. I don't want my son to be, I'm sorry, a Christian. I don't against LGBT or LGBTQ, but that's the identity when he grown up. This is too early. I don't agree that. They're trying to be, and I asked my son, "Who put this dress?" And my son told me as a foster mother many times. I said, can you dress other thing? No, foster mother asked me to wear this. And many times I asked, "Where do you get the dress?" And from the parent A mentioned it that it's get it from, what is it called, library. And I asked them, "Which library?" And they don't even give me a valid answer. I still don't understand. And then also in the House bill mentioned it that 30 days after process or after taken away consideration of my culture, they have not really put it in the action. And everybody knows action is louder than just words. And I'm very logical. And you know, if anyone acting what they're supposed to do, I will not sit in this chair.
Thank you.
You're welcome.
Do we have any questions? Representative Corson.
Thank you, Madam Chair. Thank you for being here and sharing your story. My heart goes out to you. Are you telling me that your son is being dressed as a girl in foster care? Is that what you said, or
Since
did I?
right, since he's not living with me full time, I have no idea. The only thing I see is on my visit at my apartment, multiple times she came in a princess dress. If it's one time, I understand. This is multiple occasion, multiple times. And I keep mentioning it to parent 8. And every time when I bring it that question, they say, "Can you not arguing?" I said, "No, I'm not arguing. This is concerning of my cultural." And they say, "Oh, so are you arguing because he dressed up?" No. I said, if it's Halloween, it's fine. It's not even Halloween day. I just don't understand. And I know that many people out there, like many churches, willing to help children that are away from their parents. They don't need money. They're willing with their kind heart, including myself. I'm being honest, I'm volunteering to many different organizations right now, even the past 2. I'm willing to help any other communities that need with my help as long as I'm free. But unfortunately, all my volunteering time and my hard work, they don't really take that as a credit. Everything just came out as negative.
Thank you.
You're welcome.
Thank you for sharing your difficult story.
Because
We appreciate it.
thank you, Representative Dimon, because I connected with many churches, so they're willing to do that.
I see no other questions, so I want to thank you for taking the time to speak with us. And I want you to know that we appreciate it.
Thank you, I appreciate it. I hope you do, I do support and I do not support. As long as they willing to do the hard work, then whatever it takes. Thank you.
You're welcome, and thank you. We wish you well.
Thank you. God bless you.
The final pink card that I have is for Representative Jonah Wheeler. Good afternoon, Representative, and thank you for coming.
Thank you very much, Madam Chair, and thank you for waiting for me. I had to run out as DCYF testified. I'm also in committee. We're talking about greased pigs, which is very fun. It's something, at least. I'll tell you that. But it's still happening, and it is certainly, you don't want to ascribe motive, right? Well, thank you very much. I do, Madam Chairman, also have to say I'm always privileged to come before Children and Family Law, but as a child, I'm always a little trepidatious to be before this committee with such great stature standing before you. So I am here as a co-sponsor of House Bill 1779, having heard much of the conversation. I don't want to belabor the points made, but this is, I think, an important piece of legislation, as many on this committee have spoken about in the questions asked. Culture and the heritage of an individual is key to who they are. And the more that is obfuscated or not told to them, then the more that child won't have a connection to who they are as an individual. And so the more that's the state, in whatever form or fashion, we can get this bill in a workable place for the Department of Children and Family Services, or DCY, all these acronyms, then I think that's where we should go, because these children deserve to be supported in a strong and safe and coherent way that meets their cultural heritage, no matter what that might be, so that they can live their history as an individual and meet the fullest potential that they have as a human being here in this society. And we are privileged in this state to have, I think, the resources to be able to do such a program. And, even with the existence of DCYF and all of these different programs that exist, we have affirmed that we want to protect these kids. And as what DCYF read out, the Foster Care Bill of Rights, it includes many of these things which are in this bill, as do many of the statutes as DCYF has. So I'm here to testify in support of protecting the cultural heritage of the people who have been put into the foster care or other child protective systems. And I thank the committee very much for its time.
Thank you for coming back. Your words are very well accepted. Do we have any questions for Representative Wheeler? Seeing none, thank you. You can go home now. Greased pigs. Okay, I don't have any further pink cards. I appreciate everybody's time and efforts. You've already testified. You can email it to us. Please do that. We want to hear what you have to say. So if you can please email us any further statements that you would like us to hear and read, please do that. Okay? You can email that to us. Okay, dear? Thank you. I see no further business to be brought before us today. So I thank everybody on the committee, and I thank everybody who has come here, and I specifically thank the members from DCYF for coming today and giving us all of their answers and taking all of our questions. So thank you. Go. Enjoy. Have a good time. We appreciate you all. Have a safe trip home.